Good afternoon, everyone. Thank you for joining us for today's Paid Family Leave webinar for family care. I'm Adam Rossi from the Communication and Outreach Unit here at the Workers' Compensation Board. Joining me today is Courtney Valley from our Office of General Counsel. Today we will be providing you with an overview of New York State's landmark paid family leave benefit as it pertains to caring for a family member with a serious health condition, including the addition of sibling for this year. We will also review other updates for 2023, eligibility, how to apply, a walkthrough of the required forms and documentation, some important information regarding COVID-19, as well as some frequently asked questions. We do ask that you please keep your phone lines muted, as we will be using the chat feature to receive your questions today. You should see a little chat icon on the right-hand side of your screen. You can just click on that. A chat box should pop up, and you can enter your questions in the chat box during the presentation. You can enter your questions at any time during the presentation. However, we are going to be holding off on answering questions until afterward. Courtney will be here to answer as many of your questions as she can, but if you have questions that we don't get to today, or if you think of something after the session ends, we will be providing you with resources at the end of the presentation. And I do want to mention real quick, we will be providing you with a copy of this slide deck in PDF form, as well as a recorded version of this presentation on our website and on our YouTube page. If you go to the Paid Family Leave website now, you'll see the slide deck and previously recorded version of the last webinar we did on this, on paid family for family care. So we'll give you additional resources at the end of how you can make sure you receive those as well. But for now, let's go ahead and get started. And as I mentioned, we will be sharing information with you today regarding taking paid family leave to care for a family member with a serious health condition. Since its implementation in 2018, paid family leave benefits have been significantly enhanced to further improve the lives of working New Yorkers and their families, including providing more time off, more uses of paid family leave, and more financial security. In today's presentation, we'll start by discussing why we need paid family leave, and then cover some basics you need to know, including the 3 original uses of paid family leave. Next, we'll go over updates for paid family leave for caring for a family member in 2023, including the addition of siblings as eligible family care members. We will then review the benefits, how much it costs, who's eligible, as well as steps you need to take to request paid family leave for family care. We'll then review some frequently asked questions about this type of leave, discuss information regarding paid family leave and COVID-19, point you to some helpful resources, and then again, at the end, we will answer any questions you have. So let's get started. Why do we need paid family leave? For too long, employees have struggled to maintain their jobs when they need to care for a loved one during a specific time of need. Whether that's welcoming a new baby, caring for a family member with a serious health condition, or dealing with family pressures when a loved one is deployed abroad on active military service. More recently, many employees have been challenged by having to quarantine due to COVID-19 or to care for a minor dependent child who is subject to a mandatory quarantine or order of isolation. Employees in these situations face the stress of losing income when they need to take time off to help their family, and also fear their job may be gone when the family situation is over. So, in response to these needs, New York took action. In April of 2016, New York's paid family leave, the nation's strongest and most comprehensive paid family leave policy, was signed into law. Paid family leave is employee-funded insurance that helps employees be there for their family when they're most needed. Because of paid family leave, workers across New York no longer have to choose between caring for their loved ones and their jobs, as we now have employee-paid insurance to help in these critical times. Paid family leave provides job-protected paid time off so you can bond with a newly born, adopted, or foster child, care for a family member with a serious health condition, or assist loved ones when a spouse, domestic partner, child, or parent is called to active military service abroad. Under legislation signed into law in March of 2020, paid family leave also provides paid time off and job protection so employees can care for themselves or their minor dependent child when under a mandatory order of quarantine or isolation due to COVID-19. We'll go into more details on these uses later in the presentation, as they are a bit different from the others. In addition to paid time off, New York paid family leave also has strong employee protection. You are guaranteed to return to the same or a comparable job after taking paid family leave. A comparable job is defined as a position with comparable employment benefits, pay, and other terms and conditions of employment. You are guaranteed continuation of health insurance while out on paid family leave, on the same terms as if you had continued to work. If you contribute to the cost of your health insurance, you must continue paying your portion of the premium while on leave. You are also guaranteed protection from discrimination and retaliation. Requesting or taking paid family leave cannot be held against you. Now let's look at the basic uses of paid family leave to care for a family member with a serious health condition. Having access to paid leave to care for a loved one is important for several reasons. Studies have shown it increases the quality of care in knowing a loved one is getting excellent care from their family member. It can improve pediatric, medical, and surgical experiences and better management of chronic diseases. It increases personal growth, meaning, and purpose for a caretaker. Hospitalized loved ones who are cared for by a family member may have shorter hospital stays, and with a well-established transition plan, may avoid costly hospital readmissions and emergency room use. While offering paid family leave does not eliminate the financial worries of taking time off from work, with economic support, it can help to reduce stress by providing the option to spend more time with loved ones. This type of leave you can take off to care for a spouse, domestic partner, child or stepchild, sibling, parent or step-parent, parent-in-law, grandparent, or grandchild who has a serious health condition. We do want to note that new in 2023, siblings are also included in the list of family members who are covered by paid family leave. Please check with your employer for details on when this goes into effect for your policy. A few other important notes for family care. Domestic partner is defined broadly under the paid family leave law. It includes people who are not related by blood in a manner that would bar marriage in New York State and are dependent on one another for support. So, for example, an employee may be able to prove that they are in a domestic partnership by showing that they own property together or if they have children in common. A legal relationship is not necessary. Also, it doesn't matter if these family members live outside of New York or even outside of the country. Employees can take paid family leave to care for their family member as long as they're within close and continuing proximity. So, in other words, present at the same location as the family member they're caring for during most of the paid family leave period. This may include necessary physical care, emotional support, visitation, assistance in treatment, transportation, arranging for a change in care, assistance with essential daily living matters, and personal attendant services. In order to take this type of leave, your family member must have a serious health condition. Serious health condition is defined as an illness, injury, or condition that requires either inpatient care in a hospital, hospice, or residential health facility, or continuing treatment or supervision by a healthcare provider. And a COVID-19 diagnosis may qualify as a serious health condition. Here are some examples of other conditions that may qualify as a serious health condition. Maybe you need 1 or more full days to care for your mom when she undergoes chemotherapy. Or your spouse or domestic partner had surgery and needs help recuperating at home. Or your child is undergoing treatment for addiction and cannot attend school for a period of time. These are situations that may qualify for paid family leave and may be certified by the healthcare provider if they believe the condition constitutes a serious health condition. The insurance carrier will make the final determination as to whether such conditions qualify for paid family leave. Since February of 2019, paid family leave also explicitly includes support for organ donors. Former Governor Cuomo signed legislation to expand the paid family leave law's definition of serious health condition to explicitly include preparation for and recovery from surgery related to organ or tissue donation, ensuring those who donate can be cared for by their eligible family members under the New York State paid family leave. Non-serious medical conditions such as the common cold or flu, routine dental work, or cosmetic treatments are generally not included. However, if medical complications arise and your family member then meets the guidelines for a serious health condition, the condition may be eligible. Now let's look at the specific benefits available to you under paid family leave. Eligible employees are able to take up to 12 weeks of paid family leave at 67% of their average annual weekly wage, capped at 67% of the New York State average weekly wage. An employee's average weekly wage is based on their last 8 weeks of pay prior to taking paid family leave. For 2023, the New York State average weekly wage is $1,688.19. That means the maximum weekly benefit for 2023 is $1,131.08. This is $62.72 more than the maximum weekly benefit from 2022. It is important to note that employees can take this paid time off all at once or intermittently. However, they must always be used in full day increments. To estimate your wage benefit, you can use the 2023 calculator on the Paid Family Leave website. Paid family leave is fully funded through employee contributions. The contribution rate is reviewed annually and is subject to change by the New York State Department of Financial Services. In 2023, the payroll contribution is 0.455% of an employee's gross wages each pay period. The maximum annual contribution is $399.43. This is $24.28 less than in 2022. Employees earning less than the current New York State average weekly wage of $1,688.19 will contribute less than the annual cap of $399.43, consistent with their actual wages. To estimate your deductions, you can also use the 2023 payroll deduction calculator, which can also be found on the Paid Family Leave website. So just to summarize the benefit and contribution updates for 2023, the maximum weekly benefit is increasing from $1,068.36 to $1,131.08. Also, as of January 1st of 2023, employers may deduct at the rate of 4.55% of an employee's gross wages each pay period, but capped at an annual maximum $399.43. So now that we've covered the types of leave, the benefits and the costs, let's discuss who's covered and who's eligible for paid family leave. Most employees who work for private employers in New York State are covered under paid family leave. If you work for a public employer, your employer may opt into the program. If you're a public employee represented by a union, you may be covered if paid family leave has been negotiated as part of your contract through collective bargaining. For covered employees, eligibility for taking paid family leave depends on meeting specific requirements for the amount of time employees have worked for their employer. Full-time employees who regularly work 20 or more hours per week are eligible for paid family leave after 26 consecutive weeks of employment with the same employer. Part-time employees who work a regular schedule of less than 20 hours per week are eligible after working 175 days, which do not need to be consecutive. Citizenship or immigration status is not a factor in employee eligibility. In 2021, Governor Hochul signed an amendment to the workers' compensation law which expands coverage for domestic workers. Previously, domestic workers were only required to be covered if they worked at least 40 hours per week for their employer. Domestic workers who are hired directly by a private homeowner and who work 20 or more hours a week for that private homeowner are now required to be covered for paid family leave. These workers are eligible once they have been employed with that employer for 26 consecutive weeks. Paid family leave coverage is not optional for eligible employees. You can waive coverage if you regularly work 20 or more hours per week, but won't be in employment for 26 consecutive weeks. Or if you regularly work fewer than 20 hours per week, but won't work 175 days in a 52-week period. Seasonal workers are a good example of this, as they may work full-time, but only for 3 months out of the year. If you meet the criteria for waiving coverage, your employer must provide you with a waiver form, which you can also find on the Paid Family Leave website at paidfamilyleave.ny.gov. If you waive coverage, you will not make contributions and you will not be eligible for paid family leave benefits. Employers should keep a copy of your waiver on file. If your schedule changes such that you no longer qualify for a waiver, your waiver will automatically be revoked within 8 weeks of the schedule change. You can also voluntarily revoke a waiver at any time. If your waiver is revoked, your employer will begin taking paid family leave contributions and collect any retroactive amounts due. Now let's cover how to request paid family leave when you need to care for a family member with a serious health condition, as well as how disputes and discrimination issues will be handled. If you're an eligible employee, the maximum benefit is available to you once every 52 weeks. When you're ready to request leave to care for a family member with a serious health condition, there are 3 basic steps. Step 1 is to notify your employer at least 30 days before the start of your leave if it's foreseeable, or as soon as possible. Step 2 is to complete the request form. Step 3 is to send all the required forms to the insurance carrier. The insurance carrier must pay or deny your request within 18 calendar days of receiving the completed request, or the first day of leave, whichever is later. You must submit your completed request package to your employer's insurance carrier within 30 days after the start of your leave to avoid losing benefits. Now we'll look at each step in a little more depth. Step 1 is to inform your employer. Let your employer know at least 30 days before your leave will start if it's foreseeable. So for example, you may be planning to take paid family leave if a family member is in treatment for cancer or recovering from a restorative surgery. If you need to take care of your family member unexpectedly, and 30 days notice isn't possible, for example, in the case of a sudden illness or an injury, you must notify your employer as soon as possible. Step 2 is to complete the required paid family leave request form. For family care leave, your request will contain 3 forms. The first one is the request for paid family leave, which is form PFL-1. This gives your insurance company information about you. You'll also need to provide the insurer proof that you have a family member in need of care. To do that, your family member will need to fill out a release of personal health information, which is form PFL-3, so that their healthcare provider can provide the needed proof. Finally, you'll get the healthcare provider certification, which is form PFL-4, which is what your family member's healthcare provider will use to confirm that you are taking care of a sick family member. You can get paid family leave request forms from your employer, your employer's insurance carrier, or directly from the Paid Family Leave website at paidfamilyleave.ny.gov/forms. Let's take a look at these forms. First, we'll look at form PFL-1. Every employee who is requesting paid family leave starts with this form. It asks for basic information about you and the leave you will want to take and has a section for your employer to complete as well. You will submit this form to your employer's insurance carrier along with other completed forms for the type of leave you are taking. Form PFL-1 has two parts. You are responsible for filling out Part A, and your employer is responsible for filling out Part B. The first section of Part A covers your personal information, including your address, your social security number or tax identification number, and your date of birth. You must also state why you are requesting the leave and how the family member it pertains to is related to you. Next, indicate if you expect your leave to be continuous or intermittent. You may not know all the dates for certain, so you can indicate that they are estimated, and update your insurance or your insurer if a change is needed. Finally, you must provide information about your employment, including your employer's location and phone number, your date of hire, your average gross weekly wage, whether you have more than one employer, if you are taking paid family leave from that other employer, and if you are currently receiving workers' compensation lost wage benefits. You then need to sign and date Part A of the form and give it to your employer, who will then complete Part B of the form. Before giving this form to your employer, make sure to make a copy of Form PFL-1. Your employer has 3 business days to fill out Part B of Form PFL-1 and return it to you. If your employer does not return the form, you can still proceed with your paid family leave request. As mentioned earlier, your family member will need to complete Form PFL-3 so that their healthcare provider can provide you proof that they need your care. You will be asked to provide your name, your family member's name, and date of birth. This information is required at the top of both pages of the form and is just used to make sure your insurer can match pages if they get separated. Next, your family member or their authorized representative, which can be you, must complete the rest of the release of personal health information, which gives your family member's healthcare provider permission to release the necessary information about your family member's serious health condition and need for care. If your family member can't fill out the form on their own and has an authorized representative do it, they must attach a copy of legal documentation, such as a healthcare proxy or power of attorney, to show that they are allowed to sign on your family member's behalf. Next, you must fill out Form PFL-4. You will need to provide information including your name, address, date of birth, and social security number, as well as your family member's name and date of birth. This information is provided so the healthcare provider can find the patient's file. You will be asked to provide your name and date of birth, as well as your family member's name and date of birth on the top of the second page of this form as well. You then need to provide Form PFL-4, along with Form PFL-3, to your family member's healthcare provider. The healthcare provider will keep Form PFL-3 for their records. The release automatically ends after 1 year or earlier if your family member revokes it. The healthcare provider must then complete the rest of Form PFL-4 and return it to your family member for their authorized representative, which again can be you. Step 3 is to send all forms to your employer's insurance carrier. Before submitting your forms, make sure to make a copy of Form PFL-1 and Form PFL-4. You will submit Form PFL-1 to your employer's paid family leave insurance carrier or directly to your employer if they are self-insured. This address can be found in Part B, Question 13 of Form PFL-1. This is the section your employer completed. Form PFL-3 only goes to your family member's healthcare provider and should not be sent to the insurance carrier. If the carrier's address is not on the form, ask your employer or contact the Paid Family Leave Helpline at 844-337-6303 for assistance. Also, Form PFL-4 must also be sent to your Paid Family Leave insurance carrier. or your employer if they are self-insured. The insurance carrier must pay or deny within 18 calendar days of receiving your completed request or the first day of leave, whichever is later. If for some reason your paid family leave request is denied, or you have another claim-related dispute, such as the amount of your benefits or the timeliness of the carrier's decision, you may request to have the denial reviewed by a neutral arbitrator. Your insurance carrier, or employer if self-insured, will notify you of the reason for denial and provide you with information about requesting arbitration. Arbitration for paid family leave is handled by NAM, National Arbitration and Mediation. More information on arbitration is available at NAM's website at nyspflaNAMADR.com. As mentioned earlier, your employer may not discriminate against you for requesting or taking paid family leave, and you are guaranteed job protection with the same or a comparable job upon return from paid family leave. If your employer does not return you to a same or comparable job, terminates you, reduces your pay and or benefits, or disciplines you in any way as a result of you requesting or taking paid family leave, you can file a discrimination claim with the Workers' Compensation Board. An administrative law judge may order an employer to reinstate an employee, pay any lost wages, pay attorney's fees, and pay up to $500 in penalties. The process and forms are available at paidfamilyleave.ny.gov, or you can call the Paid Family Leave Helpline for assistance. Again, that number is 844-337-6303. There are a few frequently asked questions about paid family leave and other leave policies, so we want to go over those that they may be helpful for you to know. How are paid family leave and FMLA similar? There are several similarities between New York's paid family leave and the Federal Family Medical and Leave Act. Both provide leave for bonding with a child, caring for a family member with a serious health condition, and assisting when a family member is deployed on active military service abroad. You are also guaranteed that you will return to the same or comparable position, and your health insurance will continue on the same terms as if you had continued to work. If you contribute to the cost of your health insurance, you must continue to pay your portion of the premium cost while on leave. However, there are several key differences. Number one, the paid family leave is paid. FMLA is not paid. Almost all private employers will carry PFL insurance. FMLA does not include insurance, and it has a 50-employee threshold for eligibility. The length of time you must work is also different. For paid family leave, if you regularly work 20 or more hours per week, you must be in employment for 26 consecutive weeks for that employer. And if you regularly work fewer than 20 hours per week, you must work 175 days for the same employer, which do not need to be consecutive. For FMLA, you must have worked for a full year and 1,250 hours in the last 52 weeks to qualify. The biggest distinction may be that under New York's paid family leave, you are taking leave to care for someone else, not for your own health condition. FMLA allows you to take leave for your own health condition. Paid family leave is only taken in full-day increments. FMLA may be taken hourly. Lastly, under paid family leave, you do not need to use other paid time off first. If I have a sick family member in another country, what do I need to do? It doesn't matter if your family member lives outside of New York State or even outside the country. You can take paid family leave to care for a family member living outside of New York, as long as you are in close proximity of the family member you're caring for during most of the paid family leave period. This includes time needed to travel to the family member receiving care, travel to bring them to New York, secure their medication, or make arrangements for their care. We do want to note healthcare providers outside of New York, including outside the United States, who are completing the medical certification for paid family leave must have a valid license in the state or country where they practice. If the medical certification is in another language, You do not have a responsibility to translate it before sending it to the carrier. What is needed to demonstrate a domestic partnership? You do not need to have a registered domestic partnership to take paid family leave to care for a domestic partner. The definition in the law is broad, and there are several factors that are looked at when determining whether a domestic partnership exists. These include, but are not limited to, common ownership of property, children in common, signs of intent to marry, shared budgeting, and the length of the personal relationship. For specific questions about what documentation you may need to submit to demonstrate a domestic partnership, you should reach out to your employer's paid family leave insurance carrier. What if I can't get my medical certification on time? You have 30 days from the beginning of your leave to submit your completed request without losing benefits. If you cannot get documentation to support a leave request within this time frame, the insurance carrier can deny the request. You can reapply once you have received the supporting documentation for submitting your completed paid family leave request. If the insurance carrier denies the request, you can appeal an insurance carrier's denial by requesting a review by neutral arbitration. If you started your leave before the carrier made a determination and you have since been denied, you are not considered to be on paid family leave, and it will be up to your employer to determine how to treat your time off. Your employer is prohibited from discriminating and retaliating against you for requesting or taking paid family leave. As we mentioned earlier, there are 2 additional uses of paid family leave that took effect under emergency legislation enacted in response to the COVID-19 pandemic. The legislation allows for a combination of New York paid family leave and disability benefits if you are under an order of mandatory or precautionary quarantine or isolation due to COVID-19. This is the only time you may receive paid family leave and disability benefits at the same time. It also gives you access to paid family leave if your minor, dependent child is under an order of mandatory or precautionary quarantine or isolation due to COVID-19. You may apply for a combination of paid family leave and disability benefits to receive your full pay up to a cap for some or all of the quarantine period. You may be eligible to receive 67% of your pay up to maximum weekly benefit of $840.70. Disability benefits will make up the difference in your salary up to a maximum weekly benefit of $2,043.92 for a combined total of $2,884.62 per week. There is no waiting period, and again, you will have job protection throughout the quarantine. Depending on the size of your employer, paid sick leave benefits may also be available and must be used prior to any paid family leave and disability benefits. Please note, though, this does not apply if you work for a public employer or an employer with 100 or more employees, because those employers are required to provide 14 days of paid sick leave. If you request leave for your minor dependent child's quarantine or isolation, you may be eligible to receive 67% of your pay up to a maximum weekly benefit of $840.70. More information about taking paid family leave for your quarantine or for your child can be found at paidfamilyleave.ny.gov/COVID-19. There you'll also find information about New York State's COVID-19 paid sick leave requirements, some FAQs, application forms, and more. So as you think about how paid family leave may be able to help you and your family, we do have a number of resources to assist you. Complete details on paid family leave are available at paidfamilyleave.ny.gov, along with other resources, including paid family leave request forms and fact sheets, weekly deduction and benefit calculators, updates for 2023, and information about paid family leave quarantine leave benefits. If you're thinking about taking paid family leave soon, you can download the forms now and get started on filling them out. You can also contact the Paid Family Leave Helpline at 844-337-6303 for assistance. If you're not already subscribed for email updates on paid family leave, you can subscribe by clicking Get Updates on the bottom of the paidfamilyleave.ny.gov homepage. And again, signing up for email updates will also allow you to know when resources are available, such as the slide deck and recorded versions of these webinars. So thank you for taking the opportunity to discuss the paid family leave family care with you and the 2023 updates. We'll now use the rest of the time to take your questions. Please keep in mind when asking your questions, the board is unable to provide legal advice, which includes guidance about what you should do in specific situations. If you have specific questions or concerns about requesting paid family leave, you should contact your disability and paid family leave insurance carrier, as they are the entity that makes the decision to pay or deny your benefits. As I said, we are taking your questions in the chat box, so if you have any questions, feel free to enter them. We do have a number of questions that have already come in, so Courtney and I are going to take a brief period of silence to review those, and we will be back with you shortly. Thank you.
Okay, so the first question here is asking if you can use PFL 2 or 3 weeks at a time instead of 12 weeks continuously, and the answer is yes. So if you're eligible for paid family leave and you have all 12 weeks available to you, you're generally free to take the PFL in whatever chunks you want. So if you wanted to do 2 weeks and then later 3 weeks, as long as you still have a qualifying event, that's fine. You do just need to keep in mind that if days of leave are separated by more than 3 months, you will have to apply again, because then they're considered different claims under the law.
And I'm going to move the slides back here so you have the helpline and website information available for you.
All right, next question here is, does PFL include, can I take PFL for my domestic partner's parents? And the answer there is that the definition of family member includes parent, and then parent is also defined in the law, so it is a term of art, and it means a biological foster, adoptive parent, a parent-in-law, a step-parent, or someone who stood in loco parentis to you as a child. So those are the only individuals that would qualify as a parent under the PFL law. Next question here is asking if employees need to offer proof of relationship to take PFL to care for a sibling, a parent-in-law, etc. The answer is that there is nothing specific. They have to check the box on the PFL application, and fraud is a crime. So they're testing that everything that they're saying on their application is true, and if they're lying, it's a crime. If the carrier has reason to believe that someone is committing fraud or it's just not clear, they're free to ask for more information, but there is nothing specific, but fraud is a crime. Next question here is, when the PFL calculation is done for average weekly wage, do we include paid sick time with vacation, holiday, and work time? So the answer is that it's done, you calculate the average weekly wage using the last 8 weeks the employee worked and received wages during a period of PFL. So if, like, there's a couple days in there they were working in the last 8 weeks, but they took sick time, if it's wages, meaning the employer paid it to them, and it's not, some kind of other benefit or something like that, like disability or something like that, then it's likely that that would count. So it's just wages, which are essentially any remuneration paid to the employee by the employer. There is a definition of wages in the regulations that you can look at if you really want to see it, but it's generally the last 8 weeks the employee worked and received wages, and wages are generally any money paid by the employer to the employee. The next question here is, if a dependent child is undergoing addiction treatment, does it matter if it's inpatient or outpatient? Would the employee be eligible if the treatment is outpatient? This is a very specific question, and because I can't give legal advice, I'm not going to be able to tell you, yes, this qualifies, or no, it doesn't. You can look at the definition of serious health condition. It's on the website. It's also in Section 355.9 of the regulations, but this is a very specific, fact-specific question, and I'm not going to be able to make a determination about whether a specific instance qualifies as a serious health condition or not. Next question here is, during the time you are on paid family leave, do you earn a New York retirement credit? So this is not specifically addressed in the PFL law or regulations, but the statute does say that an employee is not entitled to the accrual of any benefit that they would have otherwise been entitled to had they not taken leave. So they can't lose any benefits, and they can't be retaliated against, but they're not entitled to the accrual of any benefit that they otherwise would have been entitled to. But for specific benefits, you're going to want to talk to your employer. Our next question here is, weren't the waiver forms only for part-time employees to opt out? Full-time employees cannot opt out. So there are two categories of people who can execute a waiver for PFL. The first is employees who regularly work less than 20 hours per week, but won't work 175 days in a year. So that's your very limited part-time employees. But the other category is employees who regularly work 20 or more hours per week, but won't be in employment for 26 consecutive weeks. So that's like a seasonal employee would be a good example. Like they're only hired at Christmas for 3 months, and then that's it. That's their entire employment. Those individuals would also qualify for a waiver. Okay, next question here is there any conflict if you are the employee, but you're also the authorized signature for the employer? I am going to need to take PFL, and can I fill out and sign all of my own paperwork? So this isn't addressed in the PFL law and regulations, but it shouldn't be a problem. You might want to talk to the carrier and just explain the situation, just so they're aware of it when they get your request for paid family leave, but there's nothing like prohibiting this in the law. Okay, next question here is, can an employee continue to use PFL after the FMLA time runs out, such as if an employee uses more FMLA time due to taking partial days rather than full days at a time? So the answer is yes, assuming that they're eligible for both and they don't have any FMLA time available to them anymore. That doesn't affect their eligibility for PFL. So eligibility for PFL and eligibility for FMLA are completely separate. The only reason that we talk about them at the same time is because an employer can require an employee to take available FMLA and PFL for the same qualifying event at the same time. So if the employee is taking bonding leave, for example, and they have FMLA available to them and PFL, an employer could require them to take it at the same time. But if, for example, they already used all 12 weeks of FMLA for their own serious health condition earlier in the year, that does not mean that they can't take PFL. And the same here, if like they're taking 10 weeks of PFL, but they only have 2 weeks of FMLA available to them, the employer can require, and it's for the same qualifying event, the employer can require them to take the remaining 2 weeks of FMLA at the same time as PFL. But if the employee is eligible, they can keep going with their PFL. The eligibility is not linked. Next question here is, can I take disability and PFL together to bond with my newborn child, or is it just for quarantine? So like we said in the presentation, the only time that you can take disability and PFL together is for your own quarantine, and that's only if your employer, your employer size and type allows you to take PFL for your own order of quarantine. Generally, you cannot take statutory disability and PFL at the same time. You could, if you're eligible for both, you could take disability after the child is born and then take PFL, or just take PFL, but you cannot take them together. All right, next question here is, how do we handle changes in the employee's work schedule when there are differences between their average work week and the 8 weeks prior and when they actually take the leave? For example, they were working a 4-day work week and then they go to a 5-day work week when they take the leave. If they take a week, do we protect the 4 days or we protect the 5? So if I'm understanding you're asking about job protection, and the employee is just entitled to the same or comparable job, and you cannot retaliate or discriminate against them because of PFL. It makes no difference whether they're taking 5 days a week or 4 days a week. If you're asking about like the average weekly wage and the benefit amount, that is just the last 8 weeks that the employee worked and received wages prior to the period of PFL. So even if they, for years, worked a 4-day work week, and then like in the 12 weeks before PFL started working 5 days a week, their benefit amount is still going to be based on the 5 days because it's the last 8 weeks worked before PFL. So the next question here is, how are New York PFL benefits treated for tax purposes? So first, I just want to say that the board does not have jurisdiction over tax matters, but the Department of Taxation and Finance did issue Notice N-1712, and that notice says that benefits paid to employees are taxable non-wage income that must be included in the federal gross income. Next question here is there an expiration date to the COVID-19 mandatory sick pay for employers greater than 100 employees? And the answer is that the COVID-19 quarantine leave law, so that contains the sick pay, it contains the PFL, it contains the unpaid leave, like all of that. The COVID-19 quarantine leave specific pay, it does not contain an end date. Next question here is, what happens if an employee reaches the maximum deduction amount before the end of the year, but then they leave to go to a new employer? They paid for a year of coverage, but didn't get a year of coverage. So the benefit rate is the amount set by DFS each year. Employers cannot take more than the benefit rate, and once you reach the annual cap, they have to stop. But eligibility, deduction amount, and benefit amount are calculated separately per covered employer. So if they do go to a new employer, that employer is entitled to take deductions to cover the cost of having them on their PFL policy. Next question here is, if an employee is taking PFL due to having a baby, do they need to use up their accrued PTO before claiming PFL? And the answer is no. Employers cannot force an employee to use accruals during a period of paid family leave or before they receive PFL. So under the PFL law, Section 205, employers cannot force an employee to use their paid time off during a period of PFL. The next question here is, can payroll deductions be capped at the New York PFL income cap rather than actual earnings? So the answer is no. The rate is the rate. Like the Department of Financial Services set the rate, and it is the X percentage of the employee's actual wages each pay period. You cannot go above that and just use the cap and then stop early when they get to the annual cap, because it's both. There is an annual cap, but it's also a cap on the amount that you can take each pay period. The next question here is, when a person is using PFL intermittently, you indicated the employee will need to reapply if not used after 3 months. Does this mean completed paperwork again or doing a new calculation? So both. When days of leave are separated by more than 3 months, it is considered a new claim under the law, and so the employee will have to do everything over again as if this is the first time that they've taken paid family leave. I mean, obviously they'll put, I took paid family leave, that's part of the application, but it is considered a new claim under the law, and they will need to, when more than three months passes between days of leave, it's just considered a new claim, and they have to do everything. But keep in mind that average weekly wage is the last 8 weeks that the employee worked and received wages prior to the period of leave. Next question here is, can an employee take PFL for an adult child who is pregnant and has a serious health condition? So there is no age limit on child. If it is your child and you are eligible for PFL and your child has a serious health condition, you can take PFL for them regardless of how old they are. Next question here is, can a full-time temp employee be eligible for PFL? So I can't provide legal advice, so I'm not going to be able to make an eligibility determination for a particular individual. But if they meet the definition of employee and they work for you, they can take PFL if they meet the eligibility requirements. Sometimes with temp employees, it is a little bit, you may have to discuss who the actual employer is. Like, there may be a question about that, but it's whoever provides the coverage generally. But if an employee meets the definition of employee and employment and they meet the eligibility timeline periods, they can take PFL. The next question here is, if an employee's request for PFL is denied, but the employee is taken off time from work anyway, can they be terminated for not coming to work? So there's a few things here. First, virtually every employee that takes PFL is going to be out of the office before they before they're paid or receive a decision on their PFL, because the carrier has 18 days from the first day of leave or receipt of the completed request, whichever is later, to pay or deny the request for PFL. So almost every single employee is going to be out of work before they receive a decision on their PFL request. The second part of this is, I can't provide legal advice, so I can't tell you whether or not you can terminate an employee. Time away from work that is not PFL is subject to the employer's normal leave policies, but you also need to keep in mind that you are prohibited from discriminating or retaliating against your employees in any way because they took or requested PFL. So that's just something to keep in mind. Next question here is, what are the principal areas of litigation with New York State PFL? Assuming you mean arbitration, because all PFL claim-related disputes are subject to arbitration, on our website, we have quarterly arbitration reports, and those are just, if you go to paidfamilyleave.ny.gov, like on the screen, and you kind of scroll down to the middle, you can see, I think it says fact sheets and reports, and if you click on that, you can see quarterly arbitration reports, and it breaks down exactly how many requests for arbitration there were by topic, by type, and it has notes of decision as well. Next question here is, when does the 12-month period start and end? So PFL is based on a rolling calendar. So always on a period of leave, the carrier is going to look back 52 weeks to see how much leave the employee has taken, and then the 12 weeks, is going to be out of that. So it is a rolling calendar. It's not a calendar year. Next question here is talking about the taking PFL different weeks at a time, but this person missed what I said about the within 3 months. So the 3-month rule that I was talking about is just under the law, when days of leave are separated by more than 3 months, they are considered a new claim under the law, so you'd have to apply again. So if you took leave, like 2 weeks of leave, and then 6 months later you're going to take more leave, that's considered a new claim. You're not going to be able to use your old paperwork. You're going to have to fill out a new application. That's all. And the next question here is, are there any circumstances where the New York PFL benefits are paid directly to the employer? And so it is possible if an employer is paying an employee full wages, like full pay in like manner as wages is what the statute says. But basically, if the employer is paying full wages to an employee during a period of PFL, they can request reimbursement on the request for PFL form. So it's on the PFL one. There's a box they can check that I'm paying full wages, and reimbursement could be done by the carrier, in which case the carrier would send the check to the employer because the employee is already receiving full wages and they can't get more than 100% of their wages. All right, we have time for one more question here, and it says, this is a follow-up to an earlier question about the adult daughter. So this says, I can't take PFL for my pregnant daughter if there's no serious health condition, correct? And the answer is yes. So the qualifying events for PFL are to bond with the employee's own child after birth or placement for adoption or foster care, to care for a family member with a serious health condition, and child is included in the definition of family member, or the military leave. So if there is no serious health condition, you're not going to be able to take paid family leave to care for your daughter.
All right, thank you, Courtney. It is nearly 1 o'clock, so unfortunately we do have to wrap up. If we did not get to your question, feel free to call the helpline shown on your screen or visit the Paid Family Leave website at paidfamilyleave.ny.gov. You'll find a plethora of information there, and hopefully we can get your question answered that way. I do want to let you know, as you sign out today, you will be directed to take a brief survey. We just want to get your responses and see how we are doing with these webinars, so we greatly appreciate you taking a few minutes to let us know how we're doing and what we can do to improve our presentations moving forward. I also want to remind you that you can sign up to receive Paid Family Leave news, including information on future webinars, straight to your inbox. Sign up, you can visit the Paid Family Leave website, scroll down to the bottom of the homepage and select Get PFL Updates. We do also distribute information via social media, so make sure you follow the Workers' Compensation Board on Facebook, Twitter, Instagram, and YouTube. I want to really highlight that YouTube page where we have dozens of PFL recordings on webinars, as well as quick little snippets on what you need to know about paid family leave. Very helpful resource. We will be posting this presentation on our YouTube page, so make sure you sign up for email updates so you know when that's available. Again, thank you all for joining us, and enjoy the rest of your afternoon.